Today, we begin in the middle of a moment many green card holders fear. A legislative change that immigration attorneys had warned about, debated over, and prepared clients for. A sudden announcement, a bright flash across news feeds and immigration forums. An official memo asking questions that sound simple, but aren't. This law didn't unfold over months of public debate. It unfolded in 3 weeks. 3 weeks that could redefine your residency status. 3 weeks that could trigger automatic reviews. 3 weeks that could separate families who thought they were safe. One wrong assumption here, and you could be facing removal proceedings tomorrow. What Congress did crossed a line that advocacy groups hoped would hold. And when that line broke, USCIS did not hesitate. They responded with immediate implementation, 0 grace period extensions, and enforcement protocols that went live the same day. Most green card holders panic in this moment. They make the same mistake. They fall straight into the trap. But today, you're going to do something different. For 8 months now, there had been signals, not from official USCIS bulletins, not from formal Department of Homeland Security statements, just signals that Congress was preparing something unprecedented in modern immigration reform. The House Immigration Subcommittee has been methodical, yes, but also unusually quiet in that approach. Their actions followed a pattern, a rhythm, almost a countdown. But what triggered concern in immigration law circles this January was that the pattern suddenly went silent. Immigration attorneys who monitor congressional activity recognize the indicators. The closed-door sessions, the bipartisan co-sponsors appearing without press releases, the technical language revisions in committee markup sessions, the sudden absence of leaked drafts. And when Congress goes quiet on immigration, something loud is coming. Early February 3rd, the Federal Register detected what they described as emergency implementation language, including expedited effective date provisions not seen in over 15 years. These are provisions Congress only includes when signaling something specific. National security concerns, fiscal emergency declarations, or immediate enforcement necessity. Observers weren't sure which one applied, or whether all 3 did at once. But one thing was clear. Federal immigration policy was changing posture. And when that happens without the usual comment period, immigration advocates pay attention. The implementation notice issued by USCIS today was not routine. It was not symbolic. It was urgent. Immigration attorneys, after Emergency Bar Association briefings, described the move as sweeping, retroactive, and most importantly, self-executing, without requiring additional regulations. But legislative strategy only works if the affected population hesitates. Green card holders did not. Their response was among the most organized information-seeking efforts seen in immigration community networks. Today, multiple USCIS field offices confirmed that the agency launched compliance verification operations targeting long-term permanent residents, including those who had recently been outside the United States for what analysts believe was extended family care or business purposes. They acted before green card holders could consult updated legal guidance. They targeted residents with trips exceeding 6 months. They targeted residents with multiple absences totaling over 12 months. They targeted residents connected to sponsorship of family members still in removal proceedings. This wasn't symbolic. It was actionable. And that's what made the notice so urgent. The new law introduces what USCIS is calling continuous physical presence verification requirements. Every green card holder who has been outside the United States for more than 180 consecutive days in the past 3 years must now file a supplemental residence affidavit within 90 days of the law's effective date. That effective date was February 1st, 2026. You're already 9 days into that window. The affidavit isn't a simple form. It requires documentation of every international trip since you received your green card. It requires explanation of the purpose of each absence. It requires proof that you maintained primary residence in the United States even during extended travel. It requires employer letters, lease agreements, utility bills, bank statements showing regular domestic transactions. And here's what most people miss. The burden of proof has shifted. Under previous policy, USCIS had to prove you abandoned your residency. Under this law, you must prove you didn't. That's a fundamental reversal. That's what makes this so dangerous for people who thought they were following the rules. The law also introduces automatic flagging criteria. If you've been outside the United States for more than 90 days in any 12-month period over the past 5 years, your case is automatically referred to secondary review. Secondary review means an immigration officer examines your entire immigration history. Every visa you ever held, every extension you ever filed, every border crossing, every interaction with immigration authorities. They're looking for patterns that suggest you're not actually living in the United States as your primary home. Patterns that suggest your green card is a travel document, not evidence of permanent residence. And they're using technology now that didn't exist when most of you got your green cards. Automated systems that cross-reference your passport stamps with airline manifests. Systems that compare your stated address with IRS filing records. Systems that check whether your claimed employer actually reported wages for you during the time you said you were working. The margins for error are gone. Here's what the law specifically states. Any permanent resident who cannot demonstrate physical presence in the United States for at least half of each calendar year over the past 3 years will be presumed to have abandoned their status. Presumed. That word matters. It means you're guilty until you prove yourself innocent. You can overcome that presumption. But you need evidence. Strong evidence. Contemporaneous evidence. Not documents you create today to explain trips you took 2 years ago. Documents that existed at the time. Documents that show ongoing ties, ongoing commitments, ongoing life in the United States. The law creates 5 categories of acceptable evidence. Employment records showing continuous U.S.-based work with only brief international business trips. Educational enrollment records for you or your dependent children in U.S. schools. Property ownership records combined with utility usage data proving occupancy. Medical records showing ongoing treatment relationships with U.S. healthcare providers. Community involvement documentation like church membership, volunteer work, or organizational leadership. You need evidence from at least 3 of those 5 categories, and it needs to span the entire 3-year look-back period. If you have gaps, you need to explain them. And those explanations need to be supported. A letter from a sick parent saying you cared for them overseas, employment termination notices explaining why you were abroad, evidence that you tried to return sooner but couldn't due to circumstances beyond your control. USCIS is not accepting vague explanations anymore. They want specifics, dates, flight itineraries, hotel records if you stayed somewhere temporarily, proof that your absence was truly temporary even if it lasted months. The second major change in this law involves re-entry permits. Under previous policy, you could apply for a re-entry permit that allowed you to stay outside the United States for up to 2 years without being presumed to have abandoned your status. The permit protected you. It gave you flexibility. It acknowledged that sometimes permanent residents have legitimate reasons to be abroad for extended periods. This law restricts that protection. Now, re-entry permits are only available if you've been physically present in the United States for at least 270 days in the year before you apply. If you've already been traveling heavily, you can't get a re-entry permit to cover more travel. You have to come home first. You have to stay home. You have to rebuild your physical presence. And if you already have a valid re-entry permit that was issued before this law took effect, it might not protect you as much as you think. The law includes a clause stating that re-entry permits issued under previous regulations will be honored, but the holder must still file the supplemental residence affidavit and meet the new continuous presence standards. That means your re-entry permit keeps you from being denied entry at the airport, but it doesn't keep you from being placed in removal proceedings after you enter. The third component of this law addresses derivative beneficiaries. If you're a green card holder whose status depends on someone else's immigration status, For example, you got your green card as the spouse or child of a primary applicant. You now have additional requirements. You must prove that the relationship that qualified you for the green card still exists and is genuine. If you got your green card through marriage and you're now divorced, you need to show that the marriage lasted at least 2 years and was entered in good faith. If you got your green card as the child of a primary applicant and you've now aged out or live independently, you need to show that you established your own ties to the United States independent of your parents' status. This provision is catching many people by surprise, especially young adults who came to the United States as children on their parents' green cards, aged into adulthood, and then spent time abroad for college or work without realizing their status could be questioned. USCIS is reviewing these derivative cases with particular scrutiny. They're looking at whether you would qualify for a green card on your own merits today, whether you've committed to building a life here, whether your presence in the United States is sustained by genuine ties or just by a document you received years ago based on someone else's qualification. The fourth change involves conditional permanent residence. If you have a 2-year conditional green card, usually issued through marriage to a U.S. citizen or through certain investment programs, this law adds new requirements to your Form I-751 petition to remove conditions. You must now demonstrate not just that your marriage is genuine or your investment is sustained, but also that you've maintained continuous physical presence. The same 180-day threshold applies. The same documentation requirements apply. The same burden of proof applies. This is creating a double burden for conditional residence. You already had to prove your qualifying relationship or investment. Now you also have to prove you've been living here the entire time. For people who travel for work or to maintain relationships with family abroad, this is becoming nearly impossible to satisfy. The fifth element of this law is the one that has immigration attorneys most concerned. It introduces mandatory in-person interviews for any permanent resident who triggers the automatic review flags. These aren't the brief courtesy interviews some people have experienced at naturalization ceremonies. These are substantive, recorded, sworn interviews conducted by immigration officers trained in detecting fraud. They will ask you about every trip you took, why you went, who you visited, what you did while you were there, how you funded the trip, why you came back, why you left again. They will compare your answers to the documents you submitted. They will look for inconsistencies. They will press on explanations that seem rehearsed or vague. And if they're not satisfied with your answers, they have the authority to issue a notice to appear. That's the document that starts removal proceedings. That's the document that puts you in immigration court. That's the document that could end with you losing your green card and being ordered deported. The interview requirement is not waivable. You cannot send your attorney in your place. You cannot submit written responses instead. You must appear in person at a USCIS office. And if you're outside the United States when you receive the interview notice, you must return for the interview or your green card will be automatically revoked. There are people right now who are abroad visiting family who are receiving these notices by email. They have 30 days to appear for an interview, 30 days to book a flight, return to the United States, and attend an interview that could determine whether they keep their status. The panic is real. The consequences are real. And the mistakes people are making in response are making everything worse. Here's the trap most green card holders are falling into right now. They're trying to create evidence retroactively. They're asking employers to backdate letters. They're asking landlords to create lease amendments that claim they were living in an apartment they actually rented out. They're asking friends to write affidavits saying they saw them regularly when they actually didn't. USCIS knows people do this. They expect it. And they have ways of verifying whether evidence is genuine. They call employers directly. They check property tax records. They interview the people who signed affidavits. And when they catch someone submitting fraudulent documentation, the consequences are not just denial of the petition. The consequences are criminal charges, permanent bars from future immigration benefits, immediate deportation. The right approach is honesty, supported by whatever genuine evidence you actually have. If you were abroad for 6 months caring for a sick parent, say that. Show the medical records. Show the death certificate if your parent passed away. Show that you maintained your U.S. home during that time. Show that you returned as soon as you could. Show that this was an exceptional circumstance, not a pattern of abandonment. USCIS understands that life happens. They understand that permanent residents sometimes have compelling reasons to be abroad. What they don't accept is permanent residents who are permanent in name only, who live abroad and visit the United States occasionally to maintain a document. If that's your situation, you need to make a decision now. Either commit to actually living in the United States and start building the presence you should have been building all along, or accept that your green card status may not survive this law and start planning for what comes next. For those who have been genuinely maintaining their residency but happen to have had some extended absences for legitimate reasons, you need to start gathering evidence immediately. Don't wait until you receive a notice from USCIS. Don't wait until the 90-day deadline is approaching. Start now. Pull your passport and photocopy every page with stamps. Create a spreadsheet documenting every international trip with dates, destinations, and purposes. Gather supporting documentation for each trip. Employment letters for business travel. Family medical records for emergency travel. Gather your U.S. employment records, W-2 forms, pay stubs, employment contracts showing you were hired for U.S.-based positions. Gather your housing documentation, leases, mortgages, property tax bills, homeowners insurance, utility bills spanning multiple years showing continuous service. Gather your financial records, bank statements showing regular deposits and withdrawals in the United States, credit card statements showing purchases at U.S. merchants, IRS transcripts showing you filed taxes as a U.S. resident. Gather your family documentation, school enrollment records for your children, medical records for family members showing ongoing care relationships with U.S. doctors, marriage certificates if your spouse is a U.S. citizen and you've been living together in the United States. Gather community ties documentation, membership records from religious organizations, volunteer work documentation, professional license renewals, vehicle registration, driver's license renewals, voter registration if you're in a jurisdiction that allows permanent residents to vote in local elections. The more documentation you have, the stronger your case. The more contemporaneous that documentation is, the more credible it becomes. Email exchanges from the time you were abroad discussing when you'd return. Text messages with family making plans for after you got back. Anything that shows your mindset at the time was that you were temporarily away, not permanently gone. Once you have your documentation organized, you need to prepare your narrative. USCIS wants to understand your story. Why you came to the United States. What you've built here, why you had to leave when you did, why you came back, what your future plans are. Your narrative needs to be consistent with your documentation. If your documents show you were in India for 8 months, your narrative needs to explain why. If your documents show you made 3 trips to China over 2 years, your narrative needs to explain the pattern. Don't minimize your absences. Don't pretend they were shorter than they were. USCIS has your travel records. They know exactly when you left and when you returned. Instead, contextualize your absences. Explain the circumstances. Explain why they don't reflect abandonment of your U.S. residence. Explain what you were doing during those absences to maintain your ties here. Paying your mortgage, maintaining your health insurance, keeping your phone number active, staying employed with a U.S. company that allowed remote work temporarily. And be prepared to explain what you're doing now to ensure this doesn't happen again. If you were caring for an elderly parent who has since passed away, explain that the need for extended absences no longer exists. If you were completing a work project abroad, explain that the project is finished and you've returned to U.S.-based work. If you were dealing with a family emergency, explain that the emergency has been resolved. USCIS wants to see that you understand the requirements, that you take them seriously, that you're committed to compliance going forward. For people who realize they probably can't meet the new standards, the advice is different. You need to consult an immigration attorney immediately to discuss your options. Those options might include voluntarily surrendering your green card and applying for a visitor visa or other non-immigrant status that better matches your actual lifestyle. It might include applying for a returning resident visa if you've been abroad for more than a year and can show extraordinary circumstances prevented your timely return. It might include exploring whether you qualify for any other immigration benefit, perhaps through a U.S. citizen child who is now over 21 and can petition for you. What you should not do is ignore this law and hope it doesn't apply to you. USCIS is implementing this aggressively. They are reviewing records systematically. They are issuing notices widely. If you meet the criteria for automatic review, you will be reviewed. And if you're reviewed and found to have abandoned your status, the consequences extend beyond just losing your green card. You could be barred from returning to the United States for years. You could lose the ability to sponsor family members. You could lose eligibility for future immigration benefits. There are also special considerations for certain categories of permanent residents. If you're a refugee or asylee who received your green card based on humanitarian protection, USCIS may apply additional scrutiny if you've been traveling back to the country you claimed to fear. If you obtained asylum based on fear of persecution in your home country, and you've been making regular trips back there, USCIS will question whether your fear was genuine. This doesn't mean asylees can never visit their home country, but it does mean you need to be prepared to explain why it's now safe to visit when it wasn't safe to stay. Changes in government, changes in personal circumstances, the death of the person who threatened you. You need documentation supporting those explanations. Similarly, if you're a permanent resident who obtained status through an employment-based petition, and you've since left that employer or field of work, USCIS may question whether you obtained your green card through fraud. Employment-based green cards are premised on you intending to work in the job for which you were sponsored. If you left that job immediately after getting your green card, that raises questions about your intent. Again, this doesn't mean you can never change jobs, but the timing matters. Leaving immediately after getting your green card looks suspicious. Leaving after several years looks like normal career progression. Be prepared to explain your employment history if you're questioned. The law also creates new reporting requirements for permanent residents who work for foreign governments or foreign-owned companies. If you're employed by a foreign government entity or a company that's majority-owned by foreign nationals, you must disclose that employment in your supplemental residence affidavit. USCIS will review those cases with additional scrutiny regarding potential foreign influence concerns. This provision is catching many people off guard, especially those who work for international corporations with complex ownership structures. If you're not sure whether your employer meets the definition, consult an attorney. Failing to disclose when disclosure was required can result in your affidavit being rejected or your status being revoked for fraud. As the 90-day compliance window continues, more details will emerge about what USCIS expects in the supplemental residence affidavits. But one thing is already clear. Knowing this right doesn't make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family. Share this video with your family. It might save their life one day. Subscribe to USA Immigration Path for more protection. We protect you with real information as the next phase unfolds.